Right, time now for Sidebar. My name is Ken Mijungu, and this is the day after waiting for 20 days. The Supreme Court finally decided to deliver a ruling. It's a comprehensive ruling. We'll be delving into that with my panel next. But first, let's take a peek through the week.
Haturudi kwa kiwanja kabla tujangoa visiki. Hatujaziba mahandaki.
We now want to use unconstitutional means to change the commission and the secretariat. It is not possible.
We are prepared to pay the ultimate price to protect the constitution and the rule of law.
Kule nje anaambia wananchi hatutakanyanga hiyo bunge kwa sababu imefunguliwa kwa njia ambayo sio halali. Leo hii angalia wamejaa bunge wakijiandikisha huko wakisoma.
We cannot see how a rejected vote, a vote which is void, a vote that accords no advantage to any candidate, can be used in the computation of determining the threshold of 50% plus 1.
We still require the input of international observers.
Right, that's the best point to begin. I want to take this opportunity to introduce my guest, beginning with Joseph Simeha. Simeha is a NASA strategist, and for the purpose of this discussion, he's joining us as such. We have Otiende Amolo, the Rarieda Member of Parliament, and also an advocate. He was actively involved in the process at the Supreme Court. Thank you. And Katwa Kigen, he's also an advocate of the High Court of Kenya. Thank you, Katwa, for coming. And we have Thomas Letangule. He is a former IEBC commissioner and now an election consultant. Thank you also for coming. And finally, Charles Kanjama, an advocate of the High Court of Kenya. So my panel tonight is made up of advocates, and we had begun this discussion from where the Supreme Court left it, and that is giving a lifeline to the IEBC officials. Let's understand if that was the case, and I begin with Otiende Amolo. Was that the case? That final part that the Supreme Court judges, and especially Chief Justice Maraga, just pulled out and say we found no one criminally culpable?
No, that's not really the case. And I think this needs to be understood in context. I think it is possible that there are those who thought that the judgment today would come out and find specific officials within IEBC culpable. That could not be for two reasons. One, the petition was not about that. In our petition, we did not ask the judges to find individual persons culpable. We asked the judges to find that there were irregularities and illegalities. Secondly, under the Election Offences Act, it is not for that court to come out and find somebody culpable. Once the court has raised the issues that it did, and it did that in a variety of ways, then it is up to the DPP and the other investigative agencies to take it up from there, okay, and investigate whether those illegalities and irregularities were just mistakes, honest mistakes, or culpable offenses, and who committed them. But
when the Chief Justice spoke about we found no evidence was tabled before us that they could have deduced that someone was capable, why was he talking about something that you never presented in court?
No. What the Chief Justice says that we did not find evidence of criminal actions against any named commissioner or official.
Okay.
Now, that is not to say that they did not find illegalities. They had already demonstrated. And I think what he was trying to do, and in fairness, I think that was important, is perhaps some people are going to ask that now that you found illegalities, who committed those illegalities?
Yes.
Now, it is not for the Supreme Court to find those who committed the illegalities.
Okay.
It is for them to raise and indicate the illegalities, and then the investigative agency.
In what capacity did you sue the chairman?
Well, the chairman, anytime you go to court on an election petition, it makes sense to sue the returning officer.
Okay.
The chairman is the national returning officer for the presidential election. In fact, if you don't sue the chairman, chances are that your petition will be incompetent.
Okay, so you had to sue. In spite of that, the judge said no evidence placed before us that, which means in my mind the judges were looking for evidence from your submissions, but none whatsoever regarding the individuals. That's the reason why they reached that point.
I actually think that perhaps the Supreme Court decided to bring clarity in terms of expectations out there.
Okay.
I have seen a lot of commentators who are wrongly saying that including lawyers who are wrongly saying that we're waiting for the Supreme Court judgment so that we know the individuals who committed the offenses. Right. There is no way you could get it from there.
I take a different view.
Yes.
Okay.
From my colleague here. You see, when the court made the initial ruling that we annul the election because there are illegalities and irregularities. First of all, for a court of law to reach a decision to annul an election is a very grave matter. Therefore, we all said, let's give the court a benefit of doubt. I am an election expert. I know how elections are conducted. And I said, could the judges have found something which all the observers, all the people who are conducting elections did not see? And so this has come as an anticlimax, that they have just come with generalities. They have now again come, and this is a very specific order, that the Electoral Commission officials are not guilty of any offense.
No, that is not
That's what they say.
Letangule,
they have said, no, let me finish.
I was in court.
Let me finish.
Help you.
No, we are all been watching, so it doesn't help whether you are in court or you're watching from the screen. The thing is, they have made a specific finding that there is no criminal culpability. Okay. From there, it ends there. They are exonerated.
I like a clarity, and
could I read what the judgment has said?
Because I want to talk
it's a phrase, it's one of the last paragraphs. The judge said, although the petitioners claimed that various electoral offences were committed by the officials of the first respondent, no evidence was placed before us to prove this allegation. What we saw in evidence was a systemic institutional problem, and we were unable to find specific fingerprints of individuals who may have played a role in commission of illegalities. We are therefore unable to impute any criminal intent or culpability on either the first and second respondent or any other commissioner or member of the first respondent. We are similarly unable to find any evidence of misconduct on the part of the third respondent.
So in my mind, this is very clear, very clear. It means they canvassed this. They canvassed it. I know initially, Otiende, when you went to court, you had 28 grounds.
Letangule, first of all, Letangule is a man who should speak a little slowly on these matters. He was part of a team that bungled the previous elections. He is not likely to concede about bungling at all. So he's the last man you should ask these matters. That's number one. Number two is that, as I told you, and that is exactly what the order is, we did not seek to place anybody's name. And throughout the submissions, Katwa was there, you will find that what we sought to demonstrate to the court were irregularities and illegalities. We did not seek to ascribe any specific criminal action against anyone, because that's not for them.
All right.
We are coming to that one now.
Katwa, was this correct? What is the position? Was it canvassed?
Okay, my impression, first of all, is that in a way, I think the judges had missed out that issue, and there is a possibility that it was probably incorporated in the course of presenting the judgment. That's the first comment I wish to make. The second one is that I would have disagreed with Mr. Otiende, save that Mr. Kanjama has read it expressly, because I recall the judges saying that the petitioner had asked. So it's a very specific thing that they had asked. Now, I am aware also that outside court there have been comments about the specific people that possibly the other side of the divide have sought to remove. And so I think even as we discuss this, we need to keep in mind that there is a possibility of a distinction between what happens inside court and what happened outside. But it is my view that there was a certain sense of an anticlimax. I think there was an expectation on the part of the petitioner that specific people would be mentioned specifically. And I think it's just not that anybody, I think they had some individuals in mind, and there was some degree of disappointment that there was no consensus on that.
All right, Simeha, in your mind, let's conclude this topic.
Yes, but let me put it in broader context. What NASA has kept saying is the problem is not limited to a legal problem, and therefore the cure is not just limited to a legal cure. We've been saying that we have a political problem. The legal aspects of it are just a small aspect of it, which can be cured in law. So when you hear the judges talk about a systemic institutional problem, and I'm glad you read it because I think Justice Maraga struggled a bit and ended up saying systematic instead of systemic. Yes. It means it's an inherent institutional problem. And an institution, you can define it in three ways. The constitutive nature of the institution, you know, as a creature of the Constitution or the law and even procedures. You can also define it as the manner in which it's constructed, because once the law has made provision, then you put in place, like say, directorates and give them functions and so on. You can talk about that. And the third and final one is the character, the nature of the institutional character, organizational character. Now, when you look at these three, particularly the third one, the problem could be anywhere in these three, but particularly the third one is caused by individuals, particularly those in leadership responsibilities. Why would it be that certain institutions always they have these problems? There's a possibility that the organizational culture that has been created at IEBC is such that it's so hopelessly defective that unless something radical happens, no different results will come out.
Okay.
So we need to understand the broader meaning of an institution. And it's important that this problem be understood beyond the law, beyond the courtroom. It is a major political problem, which part of it, as I say, we cure through the courts. But a major part of it, we cure through what we do in society. You know, our Constitution is not just a legal document. It also sets political and social standards.
Okay.
And some of those standards we are saying are what people in IEBC have been breaking, that we need to cure.
Okay.
And if especially the court has found that it's not even personal or individual, it is systemic. It means it's so deep-rooted that if you just pluck out someone and put him out there and say you solved it, it won't solve. You have to go beyond that.
All right.
Yeah.
Charles? I think, Ken, when the first verdict of the court came out on 1st of September, as legal experts who have been involved in electoral matters, we were quite curious as to the finding of illegalities, because we knew that Section 83 of the Elections Act only talked about irregularities. So we were curious to find out, what does the court mean by illegalities? Has it gone outside the scope of Section 83? Is it merely talking about electoral offenses, or is it talking about some other kind of illegalities? When you read or you pay attention to the judgment of the majority, you find, first of all, they have said that the essence of the petitioner's case is founded on Section 83 of the Elections Act. So it's almost as if, despite using the term illegalities in the final verdict, they have reverted to Section 83 of the Elections Act, which talks about irregularities affecting the outcome as the essence of their interpretive lens in determining whether the election was free and fair. When you further come to actually read the judgment, as opposed to just listen to what was given, you will notice that after coming up with the legal principles and the legal rules that they are going to apply about standard of proof, burden of proof, the question of votes cast, whether they are applicable, and the question of irregularities, they come now to start applying those principles. And at the critical moment, they divide their decision into two parts. One part where they talk about illegalities. And under the part of illegalities, they're actually examining the question of undue influence, voter bribery, and so on, and intimidation, and mainly as against the third respondent. They conclude that section by saying there is no evidence presented to demonstrate illegalities. Then they come to the next section, and the heading is irregularities. Then they start discussing vote transmission mechanism, they start discussing all these issues about the forms and so on. So you get the impression that from actually the schema of their own judgment, that what they were calling illegalities that had been proven were what they have now taken back and called irregularities. And then when you come to the final paragraph where they are determining whether illegalities or irregularities were committed, again, they link the phrase illegalities with electoral offenses. And you see, electoral offenses are under the Electoral Offences Act. They are specific. You have to be concrete. you bribed, you I don't know, impersonated a returning officer. There are all kinds of offenses in the Elections Offences Act. So what you get, the impression you get, is that the Supreme Court is actually not convinced that any element that would prove illegality in the sense of criminal action under the Election Offences Act has been committed. And what they are calling illegalities, therefore, in their finding, are the irregularities that Section 83 talks about.
But honestly, if that was to be the case, why, one, did they separate them? Because it's not entirely true. I like to play a soundbite from the Chief Justice, and that's how he talks about a simple, this is not just a simple petition. And if you look at what he talked about, then it mirrors directly to illegalities, and not even irregularities. Because if you look at even the wordings of his judgment, that's totally different. And even if you look at what Philomena Mwilo, the DCJ, talked about in terms of accuracy, verifiable, and all that, do we now put it together under illegalities or irregularities? If you look at the wording, as you say, don't look at what was said, but read the judgment. Where does it fall? I'd like to play that bite first.
Let me say one thing before you play the bite. The written judgment has already been circulated, and you will find there is a section on illegality, and there is a section with a heading irregularity. So that when Judge Mwilo was talking about all these issues of transmission and so on, she was actually reading from the section under irregularities. So I'm just trying to harmonize what they were reading with the schema and the structure of the judgment as it is written down.
All right. I'll give Otiende Amolo a chance before we play the bite. Do you agree entirely? Because right now, it's hard to understand the basis of this final part of this ruling.
There are three different things that should be understood in perspective. First of all, the majority decision, when they began reading, they defined what, in the context of the judgment, illegalities were, what irregularities were. And they defined illegalities to refer to those transgressions against the written law. And they referred to irregularities as the transgressions against the administrative arrangements that have been put in place. So insofar as the judgment goes, that is the definition that they adopted. Whether one wants to argue with that or not is a different matter. However, and this is a point that I think it's been made and it bears repetition, to the extent that one is talking about certain criminal actions, then that must go to the Election Offences Act, and there's an entire procedure. On this petition, the specific criminal actions that would have been borne out in terms of the Election Offences Act were alleged against the president. Yes? Yes. It was only against the president. And for those specific allegations, the court found they were not proved, which is true. There were none, and I keep making this point over and over again. We did not make allegations under the Election Offences Act against specific officers in IEBC.
What is the import?
What needs to be understood, and I think this is the point Simeha was trying to make, there's so much around this issue. And even the things that are said out there, things that have developed subsequent to the court judgment, people are still trying to record them within the judgment. There's a lot that has happened that would amount to criminality, might even demonstrate criminality, but it was not in the context of the matter, and therefore it cannot be in the context of the judgment. And those are things that will be followed up separately. I think the closest in terms of IEBC that a criminal action would be contemplated is if we were to come to the question of contempt. You realize that the judges made the orders and they were not respected. And we are still considering that, we did not want to mix the issues. It is now time we are going to sit back and decide those who refused to implement the orders of the court, shall we now hold them for contempt? And what kind of contempt?
May I say something?
Yes.
Yes. I think probably our argument has gone more in the direction of what lawyers would discuss amongst themselves, to a point that probably it has become abstract to a common person. The point I want to make is that when you're talking of illegalities and election offenses, both of them fall into the category of criminal offenses. And that's a more grave offense, a more grave violation. and attracts a more severe punishment. However, irregularities are relatively milder situations. Criminal offenses would be things like bribery, impersonation, as Mr. Kanjama said, and so on and so forth. Irregularities could be, for instance, that there was an oversight to do something within a certain timeline, or that the proper format was not used, and that kind of stuff. And that doesn't necessarily attract as grave punishment as it would have been if it was illegalities and election offenses. And so, in a way, when you read the judgment and you see, because at the end of the decision, the judges said, in view of the irregularities and illegalities, and that word they repeatedly used, you get the impression that it is not very clear if they had a clear mind and a clear perspective of that provision under Section 83. Reacting to what Mr. Otienda said in terms of contempt, sorry, Honorable Otienda has said in terms of contempt, I think Honorable Njoki has explained it well enough. She has explained that the scope of the order they had given was actually complied with, and there was nothing that remained that would necessitate the need to initiate a process of contempt, or that would have justified the decision of the majority to annul the elections. Yeah.
Could I say something just specific and make reference to the provision of the judgment, paragraph 304. The judges said, while the impugned election was conducted in violation of relevant constitutional principles, the same was also alleged to have been fraught with illegalities and irregularities that rendered its result unverifiable and thus indeterminate. Then the judges define illegalities to refer to breach of the substance of specific law, while irregularities denote violation of specific regulations and administrative arrangements. So, for example, the Election Act is a law. If you breach it, that's an illegality. If it's the election regulations saying that the ballot paper should be dealt with this way or that way, that would be an irregularity. That's according to their definition. But after making that definition, they then go ahead and start at paragraph 306 with the heading illegalities. So and then the heading is allegations of undue influence, bribery, and voter intimidation. After dealing with that one, they then go, they say it was not established. Then they put a heading irregularities and deal with everything else.
All right. We'll take a short break. When I come back, I know Thomas wants to speak and Joseph wants to speak, and I also like you to hear what the DCJ talked about in terms of the threshold, and probably this was the core of the ruling, the whole ruling today. What they actually used in annulling this election, what did they look at? And that's also coming up as part of the discussion next. But first, let's take a short break.
In their submissions, Counsel for the Respondents and the second interested party urged us not to annul the election on the basis of minor inadvertent errors. We entirely agree. We have already categorically acknowledged the fact that no election is perfect. Even the law recognizes this reality. But we find it difficult to categorize these violations of the law as minor inadvertent errors. IEBC behaved as though the provisions of sections 39, 44, and 44A of the Elections Act did not exist. IEBC behaved as though the provisions of Article 88(5) of the Constitution requiring it to, quote, exercise its powers and perform its functions in accordance with the Constitution and national legislation, quote, unquote, did not exist. IEBC failed to observe the mandatory provisions of Article 86 of the Constitution, requiring it to conduct the elections in a simple, accurate, verifiable, secure, accountable, transparent manner. Where is transparency or verifiability when IEBC, contrary to Articles 35 and 47 of our Constitution, was still in the contumacious disobedience of this court's order, refuses to open its servers and logs for inspection.
I mean, they couldn't have put it any simpler than that. There's even a simple way that the Chief Justice put it, talking about if the same dispute with the same sort of threshold was to come before them, then they'll rule in the same way. We'll play that sound by next. But in your thinking, was it very simplistic the way it was put?
Well, not simplistic. I wouldn't call it simplistic, but I would say simple. That's something you can understand, something even the ordinary person can understand. That if you are required to carry out something in accordance with the Constitution and national legislation, and especially so in accordance with constitutional principles that are so explicitly laid out, and then it is determined by a court of law that you actually did not do that, what else can you call it? And she gives an example of the, the system that they were supposed to put in place, a simple, accurate, accountable, secure, verifiable, and transparent system. And in the finding of the court, they did not. Okay. They did not put in place this system. What else can you find, really? What else can you say? What else can you call it? If a court of law finds that you have not done what you've been asked to do in accordance with the provisions of the Constitution, very express provisions, and national law.
Okay. Kanjama. Oh, okay. I was coming to you.
I must stop Kanjama from reading that.
Yes, he's 700 pages. It's taking a lot of time.
Let me just take it up from where my brother here said. You see, in my view, I think the judges elevated the provisions in the Elections Act much higher than even giving weight to the Constitution. If you look at the section that they read, Article 86 of the Constitution, it simply says that election method must be simple, accurate, verifiable, and transparent. Now, when the judges insisted that there was an issue with the servers, and actually they went and punished, there was a lot of weight on the opening of the servers, and they found IEBC to have been in contempt. I think that was just a little bit too harsh on the commission, because there was no deliberate way in order to refuse the opening of the servers. Another aspect that...
Why would you say there was no deliberate? This was an express order by the court to open the servers. Why would you say there was no deliberate reason?
I don't think it was deliberate for the commission to refuse. But then even to answer that question further, I think a lot of emphasis was put on technology when already this election was manual in essence. Because as you can see, by the time that the issue about servers and transmissions was being made, all the forms were already brought. So in essence, we reverted back to manual. And it was the court was able to see that all the 34As, 34Bs were here. So I don't think it was necessary for the court to insist on looking at the servers and punishing IEBC for that.
Commissioner, you haven't answered. Why don't you think it was not deliberate for the IEBC not to open the servers when it was ordered more than 24 hours?
What we know is that the moment the judges made the order for the servers to be open, the IEBC itself, through their lawyer, said, we are ready and we are going to do it.
But it didn't happen.
But
and it's not happened to date.
Well, we don't know the technicalities. What we know is that...
In fairness, I think first, we need to ask ourselves, what are we doing here? Because we are not arguing what we argued in the Supreme Court. We don't need to argue that.
Yeah,
the judgment is out. So what we need to do are two things. One, to understand the judgment. And insofar as IEBC would be interested, two, to understand what is it, what are those things that we should do and what are those things that we should not do.
I agree.
Now, coming back to the understanding the judgment, my friend Katwa talked about the reasoning by Justice Njoki Ndung'u. It is important to understand that she was in the minority. Indeed, she was the only judge who spoke to that, and in her view, found that the IEBC was not in contempt of court. Now, that is not the law. That is not the position. The majority found, and you had the Deputy Chief Justice use that very difficult word for most people, the contumacious disregard of the court orders. It is curious that my friend Letangule would argue that maybe they didn't disobey, that Justice Njoki Ndung'u would say in her view they did not disobey, when the IEBC itself in court admitted that they disobeyed and sought to explain why. When you cannot comply with the court order and you bring issues like the servers are asleep in Europe and 30 minutes before the deadline, you send a message through, actually it was sent through NTV, that now, you know, we could not comply with the court orders earlier, but now it is possible to access 15 minutes to the deadline. Of course, they did not comply. But I think what's important here is this. What is important to understand is that the question of whether IEBC is in contempt or not, as a matter of law, is yet to come up. Even though the majority said, in their view, they were, and Justice Njoki Ndung'u said otherwise. That's number one. Number two, some of the things, it becomes very difficult to examine. For example, the illegalities that could have gone on in terms of the server without having accessed the server. So when we sit here, and my friend Letangule says, which is not true, and I had it also in court, the allegation that all the manual documents were brought to court, it is not true. The actual report by the court-appointed experts with the parties, regulated by the registrar, actually did find that even in court, not all the Form 34As were brought. About 500 and something were missing. Even in court, the documents that were brought were not authentic. So I want us to discuss the judgment, not from the perspective as if we are re-arguing the case, as if you don't agree with the majority or anything. But I want us to analyze it in terms of how it can help us understand what it is and moving forward.
The reason why I brought that up, is because we know already NASA is having demands that must be met before the election. And it's important, if this did not happen, if the IBC was found culpable, of which the judges say that they were not, because, as he says, there's no individual judge that was being investigated, then what happens to them? What happens to them? So this argument, to me, is very valid.
I get the impression that you want to leave the issue of contempt, and I must say something
no,
before you depart from it.
Go ahead.
Now, the first thing I want to say is that when Letangule mentioned the issue of contempt, you jumped in and said, why are you saying it's not very harsh? And I think the argument by Honorable Otiende is along the lines that it is very clear that there is contempt that has been committed. And I want to say that, to my mind, it is not that straight. And I'm in the good company of Honorable Justice Njoki Ndung'u, because he says, in his own view, it is true that IEBC complied with the order in full. Now, I appreciate, of course, that she was in the minority and that the real decision rests in the hands of the majority judges. But if the order itself, if there is no agreement, even at the level of the judges themselves, then it means that it is a very controversial order in itself, that is not, the issue of contempt is not as straight and as simple as Honorable Otiende wants to make it look like. And may I add this also, that to say that because IEBC was in contempt, then the election should be nullified, I think is very unfair to Kenyans, that a failure to comply, assuming they had failed to comply, that a failure to comply on the part of IEBC should be visited on the whole country. And my view is that the judge's decision was based only on two issues. Okay. One was the issue of that contempt, according to them, and the second one was transmission. Now, when we keep making the argument about verifiability, simplicity, and transparency, what was hard, the easiest thing, the best solution to these issues was, as Justice Ojwang had said, that it would have been to visit the Form 34As and check whether they were all there, and Honorable Otiende says they were not all there. Even assuming they were not all there, it would have been important to make out the point as to whether the ones that were missing were significant enough to warrant the need
nullify an election. I'd like to talk about numbers, because that was the substance of the case for Jubilee. But let me give you, because next I'll play a soundbite about numbers, because this was also about the will of the people versus the procedure that was used.
Yes, before we go to the numbers, let me just conclude on the issue of contempt.
He'd like to talk about contempt.
Oh, okay,
also.
very
Yes.
well. And say something that is important for viewers to realize, that contempt is like a criminal finding. You don't make a contempt finding without giving a person an opportunity to defend themselves and say why they did not comply with a court order, if indeed they did not comply with a court order. There's a process of citing someone for contempt. They come to court, they go onto the dock, and they explain what were the difficulties they faced. The truth of the matter is that it is not necessarily so that after the judges said there was contumacious disregard or disobedience of an order, that it means somebody will be found to have committed contempt. Because contempt is against an individual, while the disobedience may be against the institution. So you have to go to the individual and ask a number of questions. Don't forget that some of these individuals who are under IEBC, they gave an explanation. It may not have been a good explanation as far as the majority decision is concerned, but they had an explanation about trying to wake up people in France, in Canada or America, but and so on. That explanation was not considered in the majority decision. Yes. But in the event there were contempt proceedings, those explanations would come into play. And then something else that is very important, Ken, and I think Kenyans need to reflect on that, is that the Supreme Court was operating under very tight timelines. The orders for access to ICT materials were to be implemented within a period of less than 48 hours. And so indeed, it is possible that one wants to comply and finds that they have run out of time. I'm just saying possible arguments that could be used by someone who's accused of being an alleged contempt. No. But before I conclude, I wanted to say something to do with what my brother Katwa has said. I personally think that it was important for the court to both try and ensure verifiability of the electronic as well as the manual methods of transmission. The reason why there were those parallel means was not that you could abandon one halfway and focus on the other one only. They were meant to complement each other. So I think the court was justified in giving the orders it did. What I am wondering, though, is whether the failure to verify using one of the two means would automatically result in a finding of non-verifiability. Don't forget that there were actually 3 ways of verification, not even 2. One was through the electronic transmission. The second was through the manual transmission by the presiding officers and the constituency returning officers. And the third was by each party's agents. So you'd really need to deconstruct each of those 3 methods and show that the results do not tally, or that there is no way of determining the ability of the results to be credible before you discard the result. But the Supreme Court was very right in actually seeking to scrutinize those servers.
Again, I'll be happy to answer him.
Yes. I think it's important to speak plainly on how court make decisions, or what is considered a decision of a court of law. That once a court of law makes a decision by majority, even though they are dissenting voices, that decision is the decision of the court. I think even at some point, if in plain analysis, I would discourage insisting on the Chief Justice and the 4 judges' decision and the 2 judges' dissenting decision. Because this is a decision of the Supreme Court of Kenya, which binds. The Supreme Court of Kenya is composed of 7 judges. This is their decision as a court of law. Rather than splitting and saying, but this one also explained, we just go by what decision did the court make. And with regards to disobedience of a court order, it was that IEBC disobeyed. And I'm glad he has explained it's not at the stage of contempt. They haven't been cited. Now, there's another thing about, and Letangule touched on it, and it just reflected in my mind, why they paid so much attention on the IT requirement. And they quoted extensively the Kregler report. And they justified that quote that it was introduced, it was embedded in law, not even in regulation, embedded in law in order to cure a mischief that happened in the past that pushed this country to such a dangerous cliff that anybody else handling an election and disregarding that electronic form of transmission has to be punished. They have to bear the consequence. And thirdly and finally, that it is only when the electronic system fails that the complementary system should kick in, that manual system. I'm not sure that, I mean, they did try to say that the system, there was failure, I think they're saying failure of technology or the failure of the GSM system. But the court found, the word just fails me, the English word fails me just now. But the court found that there wasn't, you cannot call that failure. When, for example, you are lazy, if you don't get network here, and
3G and 4G.
Thank you very much, network, that you are too lazy, for example, to just move from this point to point B,
okay,
which would take you just a few minutes so that you can transmit in compliance with the law. And I think that is where they are being indicted. Did you make every attempt possible to comply with the law? And the decision is no, you did not.
And in fact, that's one of the questions that the chairman of IEBC has deponed on his memo to the CEO, and he's seeking those answers. But you wanted to answer him.
I wanted to put Kanjama's comments in context. Kanjama says there are 3 modes of verification. That is not true. He gets that language from the dissenting opinion of Justice Njoki, who actually put 5. But that is not the position. The position is the IEBC itself is required to put in a system that is verifiable. That's a requirement. But they themselves are required to verify. Those are 2 different things. Now, the obligation on IEBC to put a system that is verifiable and for them to verify is what brings the electronic and the manual. The question of parties agents does not come in at all. At all. There's no obligation. I can be a candidate today and I can choose not to have any agent. And the IEBC cannot come and say that because you didn't have an agent, it is okay for us to make mistakes. There's no such thing. But what's important to understand, and then I come to Katwa's point, without quoting the judgment because it's a lot. In the result, you will find, as the court found, that there was no electronic transmission or electronic results that you could rely on, and I think we've covered that. I don't have to cover it anymore. But even the manual, there was none. There was none first because not all the Form 34As were available. At least by the time of announcement, at least 11,000 were missing. When they were brought to court, at least 500 were missing. The ones that were brought to court were not authentic, and I think the judges covered it. The 291 constituents, 290 constituencies plus diaspora, by the time of announcement, 17 were not there. And then the ones that were there, and I think the judges covered, there were a lot of other, discrepancies that put them into question. Even the final 34C was not authentic, which brings me to the question that I think is quite popular. And that's what Justice Ojwang was saying. And Justice Ojwang, Brother Katwa, was not talking about going to the forms. His point was, the will of the people resides in the ballot box. Why don't you go to the ballot box, open it, and count? And I think we need to debunk this.
Okay. Yes.
I can tell you for a fact, and all the lawyers here who have been in election petitions know, that if you are doing actual scrutiny, the most number of ballot boxes you can deal with in one day are only 3. Because you must bring it there. They start by recording the serial number. Then they record the serial number of the seals. Then the seals are cut. Then you start looking at the documentation first before you count the boxes. In any one day, and I've done many election petitions, ordinarily, if you go for actual counting, recounting, you need about 2.5 years to deal with around 150 ballot boxes. And I've done that. I can tell you that as one of those who designed the Constitution, and I'm proud to say that the idea of bringing the election petition to the Supreme Court was my idea. We never contemplated at all, and I can tell you it can never be contemplated, that in a presidential election dispute, there will ever come a time when you open the ballot boxes and count them. You would need a lot more time. In the 14 days that the court is allowed, which actually is just 7 days, if you tried to go so far, you might cover about 30. 30 out of 40,000 does not make sense. So what is the solution? Justice Njoki suggests that you don't have to count all of them, that you can sample. Now, that's outrageous. If you are talking about numbers, if you are talking of irregularities, you can sample. You can say, let's take 10 out of 100. But if you are talking numbers, there's nothing like sampling. You must count. The reason why the Elections Act is designed the way it is with the realization that you will not have time to count. So we want to have a situation where we are sure that the actual ballot boxes and the ballot papers inside that box are captured electronically and in some document. Okay. So if you're in doubt, you go to there. You don't go to the box.
Could I respond? Because Otete has raised many points, and I think it's important for viewers to get a full context of the matter. First of all, there's been a lot of information out there in the public about what the reports say, what they don't say, and you need to read and reread the actual reports that were done by the registrar in regard to the manual forms and in regard to ICT by the ICT experts. I've reread them a number of times. The first thing I can say is that the registrar does not say anywhere in the report that 500 forms were missing. That is not true. The second thing I can say is this, that when the registrar did the report, they actually applied sampling methodology. And because I've done accountancy and I want to talk a bit about audit, sometimes we have the impression that only lawyers can resolve electoral disputes. We ignore about other disciplines that are relevant. Every day you find auditors verifying the accuracy of thousands, millions, and even billions of transactions through an audit process that may be done over 2 weeks, 3 weeks, 4 weeks. They do it. The tools are there. They may not be known to lawyers, but they exist. And one of those tools are issues to do with materiality. There are principles, sampling, random sampling. You know what methodology you must apply to sample. So in the same way an auditor will verify the accounts of Safaricom, which may be billions of entries over a period of audit of 1 month, you can verify what is in the ballot box. The way you do it is the following. You start with the form 34B, which contains the results in the constituency. Then you probably identify some areas where you think there may be discrepancy. You may do stratified sampling. There are all kinds of sampling methodologies you may use. You then go to the 34As to check, are they consistent with the 34B?
What if
this was
what
done?
If the forms? What if the
this
forms
was
are
done,
unavailable?
And then, no, the forms were there.
I'd like to ask you a question.
Let me
on
finish.
On,
let me
on
finish.
The forms,
but let me finish.
It's going to take a long
okay,
discussion. If the forms already, they were disputing the forms.
Yes.
Right? Why would you go to a form that is already disputed?
Let me tell you what happens.
Yes, it's not authentic.
The verification is a multi-level verification. You start with the 34B.
Yes, and
you dispute something.
Yes,
maybe you're saying doesn't have a watermark. Then you check. Do the 34As that fed into the 34B have those security features? You go to the 34A, you may find they have signatures of agents, they have the security features, and then they verify the 34B. Assuming you're still doubting the 34A, then you could say for this particular 34A, let's open the ballot box. So you don't need to open 40,000 ballot boxes. You open a few for purposes of sampling and verification. And I want to talk about ICT because you also mentioned something about ICT.
Briefly,
but let's finish. Okay, so on ICT, what I want to say is that there are also similar methodologies for determining verifiability. When you look at the decision of the majority on the question of logs, their concern is that even though the logs were supplied, there was no ability to confirm that they were actually from the system. It was not enough for the first respondent to say that we've given you this digital document, which is the logs from the system, but we needed to have seen the read-only. So it's not as if there was no process of verification.
I think we need to move your debate a bit.
I need to move it here, but that was necessary for that response.
The way Ochenda said, I think now this judgment has happened.
No, but let's talk about this 34A first. May I say something about that? Before we depart from that, and it doesn't mind me having to say this. I think at the end of the day, everybody who is seated in the village has the impression that actually it is not possible to confirm whether the person who was declared the president had more votes. That's the impression that people have. Now, how did the judges arrive at the decision that creates that impression? It is based solely on transmission. So at the end of the day, we are seated here not knowing who has how many votes. Now, this situation is compounded by probably out-of-court comments, including the comments that were made.
But why don't you just qualify your statement, Wakili?
Yes.
Why are we seated here and we don't know who had
It's
more
because
votes?
the judges failed to go that direction. They failed to apply the test of verifiability, simplicity, and transparency. And that would have been so simple, it would have required the counting of those
going to the ground to count the votes, because you can't get 34A without counting the votes.
Yes, and of course I appreciate the strong dissent that Honorable Otiende has. But I wonder what his position is, because presidential elections is all about numbers. And when you nullify elections like now, the impression that people have is that the person who won didn't have those numbers.
All right,
I wanted to complete just that one point. For instance, today, one of the comments made by Honorable Raila, with the greatest respect to him, is that he said that our win was stolen. Now it builds on the same issue, meaning that he had more votes than probably. Yes,
it's a fundamental point, and I think before we talk about it, because it's what I wanted to talk about next, in terms of numbers or the process, and that's what the Chief Justice talks about. What about the numbers? Where is the will of the people? Let's listen to this.
In the circumstances and in answer to the respondents' harp on the numbers, we can do no better than to quote the words of the Indian Court of Appeal, where the judge says, there is no denying the fact that the election of a successful candidate is not likely to be interfered with by the courts. The courts generally lean in favor of the returned candidate and place the onus of proof on the person challenging the end result of an electoral contest. That approach is more in the nature of a rule of practice than a rule of law, and should not be unduly stretched beyond a limit. We say so because while it is important to respect the popular verdict and the courts ought to be slow in upsetting the same, it is equally important to maintain the purity of the electoral process. An election which is vitiated by reason of corrupt practices, illegalities, and irregularities cannot obviously be recognized and respected as the decision of the majority of the electorate. The courts are, therefore, duty-bound to examine the allegations wherever the same are raised within the framework of the statute, without being unduly hyper-technical in its approach and without being oblivious to the ground realities. Experience has shown that the electoral process is, despite several safeguards taken by the statutory authorities concerned, often vitiated by use of means, factors, and considerations that are specifically forbidden by the law.
I'd like Kato to comment on that, the purity of the election.
Yeah, like I said, my understanding of the decision made by the judges is that the election was nullified on two grounds. One is transmission, and the second one is non-compliance on the part of IEBC. Now, if you were to come from the position that people went to the polling stations on the 8th, they cast their votes are intact, then a process of establishing the truth and the accuracy of those votes should exist outside the mere use of technology. And when the Chief Justice says that we don't want to be hyper-technical, the truth of it is that they were being hyper-technical actually, because at the end of the day they are saying, because we are not able to establish the accuracy of transmission, we are not confident about the elections and the results of the elections, which in my view misses completely the point, because the votes are available for ascertainment.
Okay, you talked about the time period and all, so.
In my opinion, the court from the beginning laid so much emphasis on the process, the electoral process, that it is so important that the cumulative effect of the transgressions they found is such that it compromises the integrity of the process. And in such a case where the integrity of the process is compromised, the outcome or the output of that process, it is as good as null and void. that you should not bother about numbers that are coming out of a process that is so compromised. And in part of what he quoted, talks about corrupt practices, talks about purity of the process, that it's so important to maintain the purity of the process for the output of that process also to be pure. And let me just give you two examples. The more than, at least 500,000 extra votes for the presidential position.
577.
Yes, more than the other positions. Yet it's the same electorate and so on. And then the 5,000 missing Form 34As. What do you say of that if you just want to jump to numbers? And the numbers that we are talking about, Ndugu Kigen, are the numbers that these people again disowned. Okay. Because that's what came on the screens, and it's on the basis of that that the chairman announced, and later they were disowned.
All right.
So numbers without fidelity to integrity, they don't mean anything.
I think we should move this debate in a way that can help the viewers to understand where we're heading next. As I said, the Supreme Court has already pronounced itself. It has said it has nullified this election for irregularities, illegalities. Those are very strong words. I don't want to go back to it, because one of the things they have done, they have not pointed any specifics of those irregularities and illegalities. Even what my brother here is saying, wait a minute, even what my brother here is saying about 11,000 Forms 34s, that evidence has not been clearly been tabled and proved. So what am I saying? What am I saying is that the court has spoken.
So the court ruled on the basis of non-existent
I think there was completely no basis for the court to have reached to that decision. But then let me move this. Let me move this forward, please. Allow me to analyze. Now, having said that, they made their own finding in that, because I want to talk about IEBC. They made a finding and said that there is no culpability on the part of the officials of
which
IEBC.
We have discussed extensively.
Okay? That's okay. Yes. Now, moving the process forward, what do we need to do from here? Because we cannot...
We'll talk about next, what we are going to do. But I need to... yes, I need a response on that. Yes.
Numbers. Let's make this clear. Once the court invalidates an election, there are no numbers to talk about. And that's what the court did. You cannot invalidate. It means it is void. There is nothing. You can't go and find anything. That is the essence of the Constitution, and that is the essence. Hold on, Letangule. Let me just finish. Letangule, let me finish.
To allow you to put your point in context is this. If you invalidate an election, on what basis do you invalidate an election? You must have reason.
See, now,
and you can't say numbers.
I think that is what is going to be. If you kept quiet, you would have found that my answer was coming without you interrupting. There are no numbers. It is invalidated. That's number one. Number two, once it's invalidated, the question of Mr. Kanyama saying that you can actually confirm those numbers by sampling or by some kind of audit process, that's absolutely out of the question. Not only can you not confirm them, the threshold of our Constitution is that if the numbers are valid, then you count them. But it's not enough to count the numbers. You must then go and verify, are they 50 plus 1%? Is it 25% in the majority of counties? How do you do that by sampling? It's out of question. But let me come thirdly to this. You know, the essence of what the Chief Justice and the majority said is very simple. Election is not just about numbers. Election is about compliance with the law, compliance with the process. It's a process, not an event. If it was just about numbers, let's ask ourselves this. What if in these fresh elections we are going to hold, the IEBC decided to take ballot papers only to the Nyanza region, the Western Kenya region, and the Coast region, and denied all the others? No, Letangule, please.
Okay, finish.
And then they say that for logistical purposes we could not reach the other parts of the country. And then a petition comes and says, no, let us count the numbers. It will have to be invalidated because it's a process. They would have to be asked, but how did you not take the ballot papers to the other regions? Okay. So there are a lot of things. The point I'm making is, and it's a point the Supreme Court has already made, there's no point in us debating whether it's only about numbers because it is not.
Yes.
And it is settled.
Can I respond to that? Very specific, sharp points. Please, let me go first.
Yes.
The Supreme Court begins by reviewing Section 83 of the Elections Act and the previous jurisprudence of this court, other courts in Kenya and also other courts in other countries. And it says that even though Section 83, when it adopts the argument of NASA, that you have two grounds upon which you can declare an election null and void. One is a quantitative, the other is a qualitative, and they are different. So when it goes to the qualitative, it's now not talking about numbers, but it says even though Section 83 does not use the word substantive, it is going to read in the word substantive on the basis of the words if it appears. So what the court is actually doing is it's adopting the reasoning of the United Kingdom case of Morgan versus Simpson, where the court said that you must show that the election was conducted so badly that it was not substantially in compliance with the law. This idea of substantiality is what in accounting and audit is called materiality. And it's an important point. What does it mean? It means not every infraction with the law or the regulation will result in a declaration of nullity. You must show that they were material enough. And this is a question that we are asking. Were they material enough to affect the entire result? The second point I wanted to make, which is also arising from that point, is this, that in audit, I'm going to refer to audit quite a bit at this point in time. There is something called audit of systems. In fact, we talk about internal control systems. Sometimes if the internal control system is so bad, you can't even trust the numbers at all. So you just declare that these financial statements, you cannot tell whether they demonstrate a true and fair view. What the court effectively did is they said the internal control system in this election was so bad, you could not trust the figures. And yet, they themselves recognized in the majority decision, which is one I'm talking about, that there was a voter identification, that the voters voted, there was no problem with the voting process, the agents were there, the counting was done. They actually recognized that 90% you could say of the process was without any fault. So then they come to the last 10%, and they say that there were some faults because of the internal control system. But the question still remains, how substantial were they? Were they so substantial that you could not determine the accuracy of those figures? And that's the second point I wanted to make.
The water sailed, if it comes to that.
Yes. The last point I wanted to make is this, as I wind up, that the decision of the majority, and I must be sober and honest, contrary to the submission of my colleague Simeke, has not made any finding of a mathematical discrepancy of either 5,000 forms that were not available, there's no such finding, or that there was some 500,000 votes discrepancy between presidential and the other. There is no such finding.
You've not read it.
That was, wait, let me tell you, that was an allegation made by NASA. What the court then did after listing the allegation was to ask what was the explanation given for discrepancy. The court did not find that that discrepancy existed in that quantum that has been stated.
Kanjama, read the judgment.
I completely agree with Honorable Tiende and my friend here, that it is true that if you are to find that the system, the process was so defective, then it is probable that it is justified for you not to bother to have to look at the numbers and to nullify the elections. Now, my problem with this judgment is that nobody can place their finger on what exact process issue or irregularity they are saying obtained in this case. Now, in the absence of placing their finger on that, then we should have been able to go and say how many votes did each of them get.
So you're taking us back to counting.
Yes.
You're taking us back to counting.
Yes, and I'm saying, because that's the logic of Honorable Tiende, that
actually,
you shouldn't go there.
No.
His argument is this, that you don't go into the numbers if the process is so defective. And I'm saying, you can't say, in our case, there was no process that was found to be faulty.
Even the transmission?
Transmission is not, it's just a question of how was it conveyed, and the alternative means of establishing that. The Form 34As, 34Bs, and all that were fileable. Now, may I just add one point? May I add one point?
I think
that Honorable Justice Njoki said this, that in instances where the petitioner identified the stations and the forms that they had a problem with, she took the trouble of going to look out for them. And she was satisfied that they were in good condition. Now, I know she's in the minority, but the truth of it is that there's a possibility that the other judges just took the argument about transmission and did not go beyond there to do their homework.
All right, gentlemen, we have to conclude this because we want to talk about briefly the way forward. What happens? What does this judgment portend? Because I need also to let you
so let's conclude this part.
Yes, let's conclude with Simeha and
my conclusion of this.
You want to conclude?
Just concluded.
No, I know it's okay.
I think we should leave this issue.
You know, Kanjama has asked a number of questions, but one question twice, I think even 3 times. That were the transgressions, let me call them that, material enough as to cast doubt on the integrity of the process and therefore the numbers. And it's as if there's no answer.
No,
the Supreme Court already gave an answer that they were of such weight that they cast, not just cast, they indict the integrity of the process. So therefore you cannot trust anything else coming out of that process. And then this thing of saying 90% and then it's only 10% or 5, whatever percentage, a small bit of the process that they found problems with. But what is the magnitude of that bit of the process? What is the importance of that bit of the process? Remember what I pointed out earlier, that the Kregler Commission found out that we couldn't tell the winner of the 2007 election precisely because of the process of transmission of results. And therefore they recommended that we have to go the electronic way in order to cure that mischief. And we all know where that pushed us. So for me, I can understand, even if you say this is 5, even if you say 1%, but in terms of importance, the weight, it is so critical that whoever is given responsibility, and this is IEBC, must get it right.
All right.
You know, I've just realized that perhaps because that judgment was
came out
for 11 and a half hours, some of our colleagues here may have been in between other things and may have been doing other things. Because I've heard my friend Kanjama make 2 fundamental statements which are inaccurate. He has made statements that the court did not find the specific irregularities. So he obviously missed out.
That was not
he obviously missed out. No. You also spoke to that. You spoke to that.
I didn't say specific irregularity. Please clarify.
Let me explain.
I spoke about the
thousands. You spoke about the report.
The thousands.
The court did find. And if you listen, you go back, for example, to the part that the Deputy Chief Justice read, you will hear she's referring to the 577,000 excess votes. You will hear her referring to the 11,000 from 34As that were not given. You will hear her refer to the 583 from 34As that were not brought to court. And if you look at that report itself, it actually refers to that. Now, you know, my friend Kanjama might be saying some of the things he had intended to say had he been admitted, but he didn't. But now he can't say them here. He must restrict himself to the judgment.
Absolutely.
In the same vein, my friend Kato makes an interesting statement, and it is true, that Justice Njoki went out of her way, and she's the only judge who went out of her way to do a very interesting thing. Now, I must be careful how I say this because I was an advocate appearing there. But what she did, I must say with tremendous respect, is quite curious. That a judge who is part of an interlocutory decision, which was unanimous, should come at the tail end of a judgment and appear to question that decision, because that's what she did. And in questioning it, goes back to question an officer of the court, the registrar, who themselves put there to do a particular thing, and put it in such a way as if to suggest that that registrar got it wrong. It's very curious, and it's particularly curious because she has an over 440 pages. About 80 pages are dedicated to the discrepancies. She says that without the advocates, without her colleagues, she went to where the documents were, and she herself went through a scrutiny. I can tell you, Ken, when we were preparing this case, we had 70 people working day and night for 7 days. They still could not go through the 41,883. Now, I don't want to impugn anything, but I just find it curious and unpalatable. But I agree with you that I think what we need to do here, we shouldn't put my friend Katwa to re-argue his case, because he was also an advocate in it. And clearly, you can understand why he keeps quoting the minority, because that's where he's advised. So I think let's focus.
I agree with you, gentlemen. Now, this case is set a precedent for not only for Kenya, for Africa, but all over the world. the way forward, we know it will be quoted a lot, it will be used a lot, but we still have pending business here. I want us to talk about the 60 days. We know it's done. Now we are waiting. We are looking forward to the remaining days, which is slightly less than 40. 17th, not realistic. We'll hear from the IEBC about that. But let's talk about the way forward. The judgment is out. And I like to start with Kanjama. Or should I start with...
Start with me.
I start with you. But
Yes.
the reason why I wanted to start with the 10 is just that he's spoken a lot.
Yes.
Is we know now they are moving to court. James Orengo said that what's going to happen if the DPP doesn't move, we will move, and the Constitution allows them. What happens going forward in your mind?
Okay, I'll answer what happens going forward because there is a legal and an operational dimension. And as I answer the legal dimension, all the parties have to read and really understand what the judgment of the Supreme Court is. So what we are doing here is not just relitigating. It's not correct. We are analyzing the judgment. And I think when you analyze the judgment, you'll discover there are the findings of the court, there is the observations of the court, there is the analysis of the court, there are the orders of the court. There are different aspects of the judgment. It would be incorrect to say that a discussion of the court about evidence is a finding. For example, when the court is discussing numbers, you say it's a finding and the court has not made a finding because the burden of proof of proving that there were this number of forms was not discharged by any party. That disparity, I'm responding to Otiende Amolo. But what I mean is, in determining the legal way forward and the legal interpretation, both parties will go to court. You see Ekuru Court is already in court on the question of how many people will take part in the fresh election. You are hearing threats of some people to go to court to get orders of contempt or get orders for the DPP to prosecute certain people. You'll find additional attempts to get clarity where it may not exist in the judgment as a result of what is the way forward. Even for IEBC at the operational level, they have to digest this decision because the court has clearly said your interpretation of minor Kiai Court of Appeal decision was wrong. You thought you didn't need to look at the Form 34As, that what was done by your constituency returning officers was sufficient. That was the verification. The majority has said no, you'll need to verify. So they need to revisit that question. They'll have to revisit the question of transmission. There's a question of auditing of the servers because the court has said there was contumacious disregard. We hear that the suppliers from France have said we are ready to open up and provide those things that the court said we should have provided, we didn't. Those operational issues all will arise from the judgment. Then finally, IEBC needs to deliver a free, fair, verifiable election that is better than the one they did, that they can resolve the challenges that the court raised within the next 40 days or so, because that's the period.
I have a question for you before I move to Thomas. You said no side discharged the burden. What did you mean?
You see, the petitioner made an allegation that there was a disparity of 500,000 votes in regard to the presidential and gubernatorial election. They didn't discharge that particular burden of proof. What they discharged was the burden that there seems to have been a discrepancy. So then that shifts to IEBC. Can you explain the discrepancy?
IEBC was unable to explain.
Unable to explain the discrepancy. That did not mean. Yes, that did not mean that the 500,000 had been proven. And if you read the judgment clearly, you will see that there's no finding on that. So what I'm trying to say is that you have to be clear. What is a finding? What was an allegation? What was an order? And so on.
Thank you, Ken. I think moving this process forward is that, you know, we cannot argue now. This is the final court. They have met their order. It is final. You can't go anywhere. Now, I think the best way to do, there is one fundamental finding and holding which they made, which was the culpability of the IEBC staff. To me, what it means is that they seem to have given them a clean bill of health. So they can now rest assured that they can move forward and do the next election.
Organize the election.
So I think they need to have a quick retreat, because time is not in their end, and do what we call post-election evaluation in a very short time to look at what the court has said and audit their systems, what Mr. Kanjama here has been saying. And that they need to do. Secondly, this IEBC needs to really have a way of communicating. I think largely they lost this case sometimes because they were not coming out to explain their processes. You know, in 2013, we came out and said and told Kenyans, look, these machines have collapsed. So we are resorting to manual. So what they needed to have said also is that there seems to be a problem with transmission. And therefore, we are relying on the Form 34 and Form 35.
But that was said by the chairman very clearly. He refused to announce the results until all the forms were in, and that is what Otendamolo and the team said.
What I'm trying to say,
the results were declared without the
Ken,
forms.
is that I think they need to up their communication to Kenyans. And so after that retreat, they need to come out with clear way forward. They need actually to revise what we call an operation plan for this election. And therefore, they need to come up and communicate to Kenyans first on the date of the election. Is it the 17th, or are they changing to another date? And are we sure that date is now firmed up? So they need to come up and tell us what they are doing. What are their timelines? What are they working on? When are they procuring the materials? And then they need to stop their internal wars. By the way, there is a lot of infighting in that IEBC, which is leaking to the public. Why would a chairman write internal memos to his CEO when they can sit in a round table?
That's a discussion for another day. That's a discussion. Kata.
Yeah, the first thing that concerns me is the impression I have is that the judgment has really changed the standard of proof in election petitions. And I'm really concerned about how this judgment will play out in terms of the other election issues. Now, the issue of transmission largely affects not only the presidential elections, but possibly the other election processes. So that's a concern that I have. The one other comment I have is said the main that the judges made kind of and related is ability resorting to an entirely manual means of transmitting and avoiding all these technicalities. That's all I wish to say.
All right, but they already spoke about expressly about a complementary system, you know?
Yeah.
Yes.
I think there are 3 points to be made. The Supreme Court did not give the IEBC and its staff a clean bill of health, as Letangule says. On the contrary, it was a scathing attack. They said that the IEBC handled the elections casually and equally handled the matter casually in court.
Yes.
And they didn't just stop there. They warned, and I think that is important, that if another elections was to be held and the IEBC was to handle itself in that same manner, then they will invalidate it. I mean, what more condemnation would you have more than that? Secondly, what needs to be done, in my view, it's quite simple. The IEBC has very little time. The IEBC has very little time. And instead of focusing on what needs to be done, they are focusing on what they refuse to do. One, they chose the date of 17th. It is not cast in stone. It can be adjusted, but only by a few days. One would have thought that by the time they were choosing the date, they had consulted all the players. Obviously, they didn't. One of their major players, Safran Mofo, claims that they cannot do what they need to do by 17th.
Okay.
But they don't stop there. They don't even say that if it was extended to 30th, they would be able to do it. So we have a convergence there. We, as NASA, don't want Safran Mofo. Safran Mofo says it is impossible to deliver. What is the problem then? Why don't we get somebody else to do it?
Okay.
Because in any event, what they are saying is that they would have to reconfigure. It's like doing it anew. So get somebody else to do it. That's number one. Number two, Al Ghurair. We complained about them. IEBC ignored. They supplied what they did. The court has found that what they did does not comply with the law. Instead of focusing on, therefore, how to get somebody else who can focus on the law, IEBC is telling us what they told us before 8. There is not enough time, and every day is going. They will go back to Al Ghurair. They will supply those compromised and authenticated forms. We will use them for elections. It will be nullified. Who does that help?
Okay.
The last point is this. When we say, as NASA, that we are insisting on certain minimums, for example, and as I come to that last point, what can they do internally? We have identified a number of staff who, for specific reasons, bungled this election. If it's a technical legal question that they cannot be terminated or dismissed, then what you do, and what I used to do when I was the ombudsman, is that in such circumstances, you ask somebody, if it is Kanjama, you tell him, my brother, I am not sure that you have done wrong. But Kanjama has not done wrong. But what we do is that take this compulsory leave of 6 months. Let us study and understand whether indeed there was any wrongdoing or not. Then you'll come back. All the chairman would need to do, and it does not need to go through all these processes, suspend these people for 6 months, put other people, we do the election, then they can come back. Okay. And why are we saying this? Some people are saying, oh, NASA does not want election, Raila does not want election, and if we go for elections, you'll come back and petition. Do you know why we are doing this? We are sure we are winning. But we don't want the IEBC to repeat these mistakes, because if they do, Uhuru Kenyatta will petition and it will be invalidated.
Okay. As you speak, we'll conclude with what I'm looking for in the bite in terms of if the same dispute comes before the court, what will happen? But I'll talk to you first.
Well, but he just said it well.
Yeah, he said it, but I'd like to get it from the judges. Then I'll give you...
Okay, very well. Thank you. Let me just add to what Otiende has said, that there's the legal process in terms of going forward. And already the leadership of NASA said we don't want to have an election for the sake of ticking a box. That because the court said this, because the Constitution says, so therefore in 60 days we must. When the IEBC is so internally, systemically, institutionally, is so rotten, and then we want to trust the same IEBC to carry out an election, we will end up the same way or perhaps even worse. And unlike what my brother Tangule here says, IEBC cannot easily cure itself. This has to be a societal, it is already a societal problem. And that's why, as the leadership of NASA is saying, let's come together as a society. It's not about, NASA is not competing with IEBC, as Ruto likes to say. NASA is pointing this out for the sake of society. It just happens that the next immediate election is the presidential election. Let me tell you, if the next immediate election were going to be a parliamentary by-election in which NASA is involved, it would say exactly the same thing. Okay. We are not going to that election without sorting out these irreducible minimums. Okay. And it's about curing IEBC of this mischief that is hurting not NASA, not Raila Odinga, the entire Kenyan society. All right. So going forward, we must sort this problem as a society.
All right. I'd like us to conclude. You'll say what you want to say in your closing remarks, but before I give you an opportunity, all along as we covered the Supreme Court case, we were told when we ran the tag of Odinga versus Kenyatta, a lot of NASA supporters told us that this is not about Odinga, this is about the country. So as you conclude in less than 30 seconds each, because I have to let you go, I'd like you to reflect on that. But first, let's listen to the Chief Justice.
How can this court close its eyes to an obvious and near total negation of the transparent process? In keeping with our pronouncement regarding the burden and the standard of proof in election petitions, we are therefore satisfied that the petitioners have discharged the legal burden of proof as to squarely shift it to the first and the second respondent. We are also of the firm view that having so shifted the burden has not in turn been discharged by the first and the second respondents as to raise doubt in regard to the petitioner's case. For the above reasons, let this judgment then be read in the proper context. The electoral system in Kenya today was designed to be simple and verifiable. Between the 8th of August 2017 and the 11th of August 2017, it cannot be said to have been so. The petition before us was, however, simple and to the point. It was obvious to us that IEBC misunderstood it, hence it jumbled up responses and submissions. Our judgment is also simple and, in our view, clear and understandable.
All right, gentlemen, we have to conclude. I have to let you go. And unfortunately, I'll begin with Kanjama again. Very briefly, if you go beyond 30 seconds, I'll cut you. Okay. We have to conclude. I have to let you go. Yes.
They say that the best is the enemy of the good. Procedure is meant to be a handmaid of substance. Technicalities should not become the master. What you find is that the most important thing for IEBC and for the country is that we must try to avoid cannibalizing institutions, preserve the institutional integrity. The NASA team has genuine concerns, but if you implement all their irreducible minimums, that is the enemy of the good. The Jubilee side also has genuine concerns about the need to avoid a constitutional crisis. You need to work through this minefield, get the best case scenario where you preserve the institutional integrity, you address the concerns of NASA that can be addressed, you address the concerns of Jubilee that can be addressed, you deliver the best election you can in the next 40 days. It will not be perfect, but it should be good enough to withstand the scrutiny of the Supreme Court.
Exactly. And picking up from there is that, Ken, I think now that the Supreme Court has spoken, I think that all sides need to read the judgment in totality. You cannot then say, when the court says that they have exonerated the IEBC officials, then the other party still keeps on insisting that they did illegality when the court has already cleared them. So going forward, we need to give support to this IEBC. You cannot bring conditions which you know very well they can't work. If you insist, for example, that ballots must be gotten from elsewhere, that you must again procure new KIMs, where is the time to do that? Unless then we don't want an election. So what am I saying? I think we need to allow the commission to work. And we need now that the court has said this, that they need to comply with, I think they will do it within the parameters that are set.
All right, Kato.
Yeah, I think I will more or less say the same thing as what my two colleagues have said, that the call on all of us now is to responsibly assist the IEBC to be able to discharge their mandate within the time frame. And I'm glad that Honorable Tienda, on his own motion, has thought it necessary to be on the defense and say that the conduct that we have seen from that side of the divide is not necessarily calculated to frustrate the process of election, but rather to improve on it. The point I'm making is that it quite clearly acknowledges the fact that quite a number of people think they are being difficult with a few to frustrating the build-up to elections. And I would just want to pray that we all cooperate to assist the discharge of these elections. I clearly disagree with the majority decision, but it's final. I must say that looking at the complement of the judgment, the three decisions by the majority, by Justice Ojwang and by Justice Njoki Ndung'u, it really takes up the practice of law, and I think quite a bit of conversation will be in that circle also.
Thank you. For quite some time, and not only here.
Just 2 points. First of all, I think that the one thing that the IEBC needs to do is adopt what the courts have done. Courts don't just dispense justice. They make sure that each step of the way they carry you, so you see. That's what IEBC is not doing now. They have basically locked themselves that we have 60 days. We don't know what's going on. They once in a while call you for a meeting. It is unstructured. The IEBC needs to engage, needs to be open, and need to be structured. The chairman sent a memo to the CEO. We need to know what his response was so that we deem whether it's reasonable or not. And if there's any counter, as indeed there was, then we also need to know that. You don't have IEBC that says this was an internal memo. How did you get it? No. There's nothing internal about the person who's standing for elections. That's one. Number two is that I think the one thing, and I'll say that quite, when we raised the issues before 8th of August, we as NASA, we were deemed to be those who are trying not to go to the elections. The very same issues that IEBC ignored with the being defended by Jubilee, those very same issues are now what came to pass. We took them to the Supreme Court. It has resulted in nullification. Had Jubilee agreed to play, as we are now still inviting them, it's not a question of defending or accusing IEBC. It's a question of trying to make sure there's compliance with the law. And I agree with Kanjama. Let us look at what is the things that we must do to hold credible elections so that you don't go and say, oh, that person cannot go, this one cannot go, but let's reason together meaningfully.